Welcome to New Hampshire's Business. I'm Fred Coker. Medical marijuana is legal in New Hampshire, but is its use legal where you work? We're going to talk about that with my guest who has to deal with this with his clients at his law firm. But first, let's look at what marijuana in New Hampshire is really all about. Therapeutic cannabis program started in 2016. There are 5 medical marijuana dispensaries: Merrimack, Dover, Plymouth, Conway, and Lebanon. 8,566 persons are qualified as of September in New Hampshire to use medical marijuana. But recreational marijuana, of course, is not legal in New Hampshire, although we're surrounded by it with other states. Now, this legal fog for employers and employees, what we're going to talk about on the whole issue of marijuana, in one form or another, may be legal in New Hampshire and 32 other states, medical that is, but pot in any form is illegal under federal law. So what are the rules for employers and employees? To find out, we're going to talk to my guest, who is Jim Reedy, who is labor attorney at Sheen Finney law firm here in Manchester, and you have other locations. And in an interesting way, because you're now dealing with marijuana legal issues with your employers that come to you, called the pot attorney in your law firm, right?
I prefer other names, but sure.
No, and Jim has a great background. In fact, on this issue, they've been reaching out from the New York Times, the Wall Street Journal, Bloomberg, the Washington Post, and so forth. Have reached out to Jim because he is an expert on this issue. Now, let's talk about this. Jim, what are you seeing with your practice? I mean, employers are coming to you, and what are they coming to you with?
I think a couple of things. I think that one, the changes in the law. In the last 5 to 7 years, we've seen this explosion in legalization. 33 states and the District of Columbia have legalized marijuana in one form or another. 11 states have recreational marijuana approved, and there are more in the pipeline. At the same time, we have a labor shortage. So a lot of employers are saying, how do I comply with the law? And if they have operations in more than one state, and should I test? And if I test, what should I do with regard to my policy and so on?
Mm-hmm. Yeah, it's a real dilemma. Let's. You had some PowerPoint that you did that when you go out speaking to organizations, and you do some true and false questions. They're kind of interesting. Let's put the first one up. And here's the first true and false question: employees who have a medical marijuana identification card must now be permitted to work with pot in their system. True or false? Jim?
And that is false. That is generally false. And that is because it is still an illegal substance under federal law.
Right.
However, some states, including our neighbor state to the south, Massachusetts, there was a case where someone had a medical marijuana card, mm-hmm. and they and tested positive and was fired from the job. And that employee challenged it, and the Supreme Court in Massachusetts said you should have had a discussion about reasonable accommodation in the person's use.
Interesting. Talking about accommodation, here's the next true and false question. Pot use may be a reasonable accommodation under the Americans with Disabilities Act. True or false?
And that is false. Because under the statute as it was adopted in 1990, effective in 1992 and amended in 2009, so that it's been around for a while, but from its earliest stages said that illegal narcotics, Schedule I narcotics, may not be used for purposes of a reasonable accommodation.
I mean, employers are faced with the ultimate issue, and that is whatever the states do on marijuana, be it medical or recreational, still federal law prohibits it.
That's right, but it's rapidly changing. So the example of the Americans with Disabilities Act, while you cannot use that as a reasonable accommodation under federal law, it may not be prohibited under state law, setting up a potential challenge between federal and state over this issue.
Now, here are some things that you suggest to employers, and let's put up the graphic. As policy, best practice for employers prohibits sale, use, distribution, manufacture, or possession of alcohol, prescription drugs, reserves the right to test for drugs and alcohol, confidentiality of testing and medical records. And then these, describes consequences of a positive drug alcohol test, requires employees taking prescription meds that may affect performance to notify the employer, trains supervisors to spot signs of drug alcohol issues, and offers employee assistance resources. Comment.
So the first thing is, should we have a policy? And because you want to deal with employees who say, well, I never knew that I couldn't have this on the premises, or I couldn't have it in my system, and so on. Sounds kind of silly, so have a policy.
Have a policy, yep.
And then make it clear that you can't have paraphernalia, you can't distribute it, you can't have it in one form or another, edibles or otherwise, because it can be something other than something that you smoke. And make it clear what the consequences are.
And you have a brisk practice in this area.
Very.
Very. Jim Reedy, labor lawyer at Sheen Finney Law Firm. Thanks.
My pleasure.